how does Porsche and Disney get together to create this? That's one example, a television commercial, but there's all sorts of other examples, right? Creating products or branding your products in some way, as well as integration into the films. And so why don't we start with this question, right? The term sheet, which is also one of my first questions, right? Do we do some sort of a deal memo or a term sheet? Is it worth it to do it before we get into the negotiations? And I don't know, it's been my practice in dealing with the entertainment industry. You negotiate, you negotiate and negotiate, and then you end up never signing something. That seems to happen quite a bit. Am I wrong? Especially some of the things that I've been working on. But what's your point of view on that, Jesse?
I think from a studio or entertainment company perspective, more often than not, these will be non-binding agreements. It's good to have, obviously, because you want to make sure that, at the basic level that there's a meeting of the minds, but typically you just want to outline the major deal terms, but it's not going to be anything binding. Every LOI I've ever seen, every term sheet, it will probably have something in the header that says non-binding terms or something along those lines. And it's really just for the business teams to outline everything. To the extent that there's ever a brand that wants to add boilerplate provisions like, oh, let's add indemnities, let's add grants of rights. It's like, well, then why don't we just go straight to the final agreement and just go directly, as opposed to negotiating it in a deal term sheet or something along those lines. But typically not really binding, but it's good to have, because more often than not, maybe some of you have experienced this, sometimes a client will provide you with something. It's like, here's the major deal point. We'll fill in all these blanks later. It's better to have it up front, and it just makes the negotiation that much easier. So.
Yeah, I mean, from my perspective, I'd rather have a binding term sheet, of course. Yeah. But the other thing is, it seems like these, in my experience, these deals are so flexible, right? There's some major parameters about what's agreed to, right? Okay, we know you're going to get exclusivity, as an example. We know that there's maybe a media commitment of a certain amount of millions of dollars of media commitment, and maybe there's some social media integration, or who knows what. There's some basic 10 deal terms, and then the rest is sort of like, okay, we'll get to that eventually, right? So a lot of the times, even the business points are still being negotiated. So I can understand why it wouldn't be binding, although I would rather it be. Yeah.
And just
go ahead.
And if there's ever an urgency, sometimes people want to sign deal memos or LOIs or term sheets because they need to proceed to whatever the production is immediately. There are always ways around that. Obviously, you probably have a standard confidentiality NDA in place, but you also have things like artwork release letters where we can release specific assets just so you can get the concept level things going while we negotiate the deal, because sometimes these deals come in pretty quickly and we have to turn it around equally as quickly. So, yeah.
Great. Are you ever faced with situations where it's like literally at the 11th hour, you're getting ready to release the movie and you're getting a new brand partner? Is that happen a lot for you?
Never. No, actually, it does happen quite a bit, and we always try to find a creative solution to make it happen. Sometimes we'll stray from what would be a master promotional license agreement. Sometimes let's just do a quick one-off advertising agreement just to get it in place, and if there has to be an amendment later. But yeah, it happens all the time. I think I was just telling Joseph we have a little Frozen 2 thing that we're dealing with right before I was coming in, and that releases, in 48 hours. So yeah, happens all the time.
Frozen 2 an emergency. You never thought you'd hear that, right? This next topic, since I represent agencies primarily, is just a question for Jesse in terms of what his opinion is in terms of getting an agency involved, right? Many of the ideas for the product integration and licensing deals start with either the creative agency or the media buying agency working with the brand. And the product integration deals as well are almost always done through a media buying agency, and it could be some sort of value-added play in connection with the media buy, right, for a particular network, for example, if you're talking about television integration. But I'm always representing, or almost always representing, the agency, and so there's always sort of a delay, if you will, in terms of my getting my information from my client, who ultimately gets their information from the brand. Have you had any positive or negative experiences in dealing with a situation like that?
Little of both. Little of both. I think you and I have had situations where the agency will negotiate everything seemingly, from beginning all the way to final execution stage, and then it goes to the brand company saying, great starting point. Now here are my comments at the 11th hour. Obviously something you don't want. My experience has been if we have an agency that we're dealing with that we've dealt with over the years in good standing, that makes things smoother. But if it's a new agency that we've never dealt with, and it's also perhaps even a new brand, typically we will want one of two things. Let's have a conversation with a representative from the brand just to make sure that everything is on the up and up. And oftentimes I've even had experiences where the brand will actually provide, hey, here's a document. This agency is actually authorized to negotiate nuts to bolts, everything for us from beginning to end. Some will even go so far as to say the agency can even sign on our behalf. And even one step further, the agency can actually be the contracting party on behalf of the brand. Now, obviously, we have to go through a few more steps to get to that point. We want to make sure that, insurance is in place, liability issues, all of that. But sometimes that happens. And, again, my experience is transparency. As long as we don't have the scenario that I described at the outset, which is all of a sudden the brand comes in at the 11th hour with additional comments, have a representative involved, or maybe have that conversation at the beginning so that we know. But oftentimes nowadays, a lot of the agencies that we deal with pretty regularly, they know the drill, we know the drill, so we're pretty comfortable. And not that we're gonna get ethics credit for this. Obviously, a lot of agencies sometimes wanna negotiate without their attorneys on the call. Obviously, we always want the attorneys on the call. Maybe we should get a little ethics credit just for mentioning that, but anyway.
So. At least a quarter of an ethics credit for that, right? The situation that Jesse is mentioning happened to us, and it was pretty embarrassing from my perspective because the in-house counsel at the brand basically said to the agency and to me, go ahead and negotiate this, don't worry about it. And of course, as an attorney representing the agency that's representing the brand, right, you're checking in periodically. Hey, what do you think about this? What do you think about that? Mostly major issues, things that are of primary importance to the brand. But then, as attorneys, and we've probably all seen this, right? You get a piece of paper in front of you and you can't help but take out the pen and mark it up. And so then it's about, in that situation, it was me, helping walk the in-house counsel of the brand through the decision-making process that we went through. And it's a lot of Monday morning quarterbacking there, right? Jesse and I are negotiating along. He's saying no to like 90% of the things that I'm offering. Just kidding.
88.
And thank you. So awkward situation, but ultimately you work those things out. So after having that happen to me at least once, I'm always of the opinion that I want the brand involved as closely as possible with that. Jesse, you bring up an interesting issue with respect to the agency acting as agent, right? So typically, historically, advertising agencies and media buying agencies were granted true agency through the agreement, and that's just the way it was. The pendulum has swung mostly to the other side, in which this notion of an advertising or media buying agency acting as a true agent pursuant to the law is really no longer there, although it does happen. Do you, in terms of those extra things that you ask for, because from my point of view, I'm like, we're an agent, we have the authority to act as agent, we're going to sign it as agent, that gives you apparent authority. Do you really need additional things? Do you need the brand, for example, to sign an additional document, or are you happy dealing with just, okay, XYZ agency as agent for, Porsche Cars North America?
Yeah. No, it's a fair question, and I think it can differ by studio or entertainment company. I think, at least I can speak for Disney, obviously, if you're going to be using our assets, we want to know who it is and that this person is authorized or this company is authorized. So, a one-sheet document that basically says, confirming exactly what we're all saying, shouldn't be too much of a Herculean task to get that into place. That's at least our perspective. We want to make sure, again, that everything is above board. But yes, in principle, we don't necessarily have a problem with dealing with agencies. But yeah, on the Disney side, we do want that extra security of knowing that, okay, yeah, Toyota's on board or Gillette is on board or whoever it is on board, and we want to make sure that all T's are crossed and I's dotted.
From your perspective, why take the risk, right? Although typically in that scenario, if you came to me and said, okay, here's a one page piece of paper that I want the brand to sign, I don't I may or may not have a direct relationship. Their usual response is, and by the way, you're dealing with big brands usually, right? Their usual response to that is, why do they need that? Clearly the agency is acting on our behalf, blah, 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 blah. So it's one of these annoying things where you have to convince everybody involved that, look, it's not really a big deal. Yes, we have authority to act, on your behalf in that scenario. So, just sign it.
Yeah, and just as a side point, sometimes there are companies that don't have the ability due to certain restrictions to even contract directly. Sometimes if I'm doing a deal with a government agency, sometimes government agencies cannot contract with Warner Brothers, Disney, or Universal. They actually have to go through an agency because of bylaws or actual, government laws, restrictions. So sometimes you actually have to go down that path.